In this episode, we will be discussing Alaska Landlord Retaliation Prohibited. The Alaska Uniform Residential Landlord and Tenant Act outlines the following restrictions regarding landlords taking retaliatory actions against tenants. Retaliatory conduct prohibited. Except as provided in the subsections lawful landlord action for possession and lawful rent increases, a landlord may not retaliate by increasing rent or decreasing services, or by bringing or threatening to bring an action for possession after the tenant has done any of the following: complain to the landlord of a violation of the laws of our other video titled Alaska Landlord Responsibility to Maintain Premises, sought to enforce rights and remedies granted the tenant under this act, organized or become a member of a tenants' union or similar organization, or complain to a governmental agency responsible for enforcement of governmental housing, wage, price, or rent controls. It is important to note, if the landlord acts in violation of this subsection, the tenant is entitled to the same remedies provided in our other video titled Alaska Unlawful Removal of Tenant and has a defense in an action against the tenant for possession. Lawful landlord action for possession. After serving a notice to quit to the tenant under our other video titled Alaska Notice to Quit Form and Laws, a landlord may bring an action for possession if the tenant is in default in rent, compliance with the applicable building or housing code requires alteration, remodeling, or demolition that would effectively deprive the tenant of use of the dwelling unit, the tenant is committing waste or a nuisance, or is using the dwelling unit for an illegal purpose or for other than living or dwelling purposes in violation of the rental agreement, the landlord seeks in good faith to recover possession of the dwelling unit for personal purposes, the landlord seeks in good faith to recover possession of the dwelling unit for the purpose of substantially altering, remodeling, or demolishing the premises, the landlord seeks in good faith to recover possession of the dwelling unit for the purpose of immediately terminating for at least 6 months use of the dwelling unit as a dwelling unit, or the landlord has in good faith contracted to sell the property and the contract of sale contains a representation by the purchaser regarding his or her desire to use the dwelling unit for personal purposes or substantially alter it or not use it as a dwelling unit at all for at least 6 months. Lawful rent increases. The landlord may increase the rent if the landlord has become liable for a substantial increase in property taxes or a substantial increase in other maintenance or operating costs not associated with compliance with the complaint or request, not less than 4 months before the demand for an increase in rent, and the increase bears a reasonable relationship to the net increase in taxes or costs, has completed a capital improvement of the dwelling unit or the property of which it is a part, and the increase in rent does not exceed the amount that may be claimed for federal income tax purposes as a straight-line depreciation of the improvement, prorated among the dwelling units benefited by the improvement, or can establish by competent evidence that the rent now demanded of the tenant does not exceed the rent charged other tenants of similar dwelling units in the building, or in the case of a single-family residence, or if there is no similar dwelling unit in the building, does not exceed the fair rental value of the dwelling unit. For additional laws and articles, visit AmericanLandlord.com.